How do you define reasonable doubt? Reasonable doubt, we start with the words. What is the etymology of reasonable doubt? It means that doubt that is reasonable. And if there is no doubt that is reasonable, then the juror is obligated not to convict the accused. Reasonable doubt is often associated and explained to jurors with those things that the jurors would consider most important to them, matters of the utmost importance. For example, buying a house. Give the same consideration to reasonable doubt as you would buying a family home that you're going to live in for the rest of your life. You must be sure you want that house. You must be that sure that the accused is guilty. If you believe that the accused is just as possibly guilty as non-guilty, then the juror must acquit the accused. If the juror believes that there's a possibility that he's guilty, he must acquit the accused. If the juror believes that it's more likely than not that he is guilty, he must bring in a verdict of not guilty. In other words, he has to be so sure of the defendant's guilt that he would rest his own soul on it. That's a high standard, and it's a high calling for a juror, and it's no small matter. And it's given to jurors because those that are trained in legal matters, such as judges and attorneys, are just simply too used to it. And they can't bring all of their being to bear like a juror can. A juror brings his guts and his conscience. And a judge and an attorney or a prosecutor or a law enforcement officer may not do that. And reason alone is not enough to convict. The juror's whole soul has to be put into the decision.